All right, welcome to the Great Trials Podcast. This is Steve Lowry with Yvonne Godfrey. Yvonne, how are you holding up? I'm in a hotel in Athens, Georgia, right by the beautiful University of Georgia right now, and it's pouring rain here.
Yeah, I'm holding up. I'm a little jealous that you're in Athens, although not the best weather for it.
I'm in Athens, stuck in my hotel room because it's way too wet to go anywhere.
That makes you prep for the depots instead of
That's right.
doing maybe other more fun things.
That's right. That's right.
Well, you're in the town of one of my alma maters, and we have a graduate from one of my other alma maters on the show today. I'm so excited. So let's go ahead and introduce our guests, Ron Johnson and Jay Vaughan. They are both from the law firm of Hendy, Johnson, Vaughan, Emery. They're in Kentucky. They've got offices in Louisville and Fort Mitchell, and you can look them up at justicestartshere.com, one of the easiest websites we've had in a while, Steve. But Ron and Jay, thank you so much for being here today.
Thanks for having us. We're excited.
Well, y'all have a great result for us to talk about, a great case. There's so much to talk about in this case. I think it's going to be tricky to fit it all into the time that we have to talk about it. Before we dig into that, I want to tell our listeners a little bit about you for those of our listeners who don't know who y'all are already. And as I alluded to, one of our guests, Ron, went to Rhodes. I'm pumped for I know we've got at least one other Rhodes College listener, which is Peyton from our firm.
We scour the Rhodes campus looking for people to come work for our law firm.
Yeah. So excuse me for doing
somehow we missed out on Ron. I mean,
somehow. So excuse me for doing a little Rhodes pandering to the Rhodes fans. Yeah. Ron has spent his career representing families and people who've been injured by defective drugs, medical devices, dangerous property conditions, semi-truck collisions, all of the big cases that you would expect from a Rhodes graduate. He's an AV rated lawyer. He's a former president of the Kentucky Justice Association, many times super lawyer. And he's done something that some of our guests have done, but I think is really tricky, and a lot of responsibility, which is he's held numerous leadership positions in nationwide litigation, has served as lead or co-counsel of multiple multi-district litigations, which we've done a few episodes about cases like that. And it's a ton of work. Ron has tried numerous complex cases, including a medical device case that resulted in a verdict of over $7 million. The tremendous result that we're going to talk about today, so I won't talk about that yet. It has negotiated settlements up to $230 million, not too shabby. So Ron, and I didn't even ask if I can call you Ron, since you're
yes. Yes.
Okay. Yes. So Ron, thank you for being here.
Thanks for having me.
And I will tell everybody about Jay next. Jay has got we were talking about it before we started recording. He's got a Zoom setup that is better than mine and Steve's. Yes. So we have no excuse for that, Steve. We gotta up our game. Jay is from Louisville, Kentucky. He went to undergrad at Murray State and law school at Salmon P. Chase College of Law at Northern Kentucky University. He's also an AV rated lawyer and a many-time Kentucky super lawyer. In 2020 and 21, Jay was recognized as one of the top 50 Kentucky super lawyers. Jay has tried tons of cases also in difficult areas, automobile collision to nursing home neglect cases. And he is board certified in trucking accident cases through the National Board of Trial Advocacy. And he serves on the board of both the Kentucky Justice Association and AAJ, which we talk about a lot. So Jay, thank you for being here with your fancy Zoom setup as well.
Thanks for having me. You know, I mean, when COVID hit, I had to start investing in this stuff because we did so many depositions from our home and and remotely, which Ron and I know we'll talk about this trial, about all the work we did during COVID to get this to trial. But so, you know, my first microphone headset, people complained it didn't work, so I had to buy another one. So, you know, it eventually got it right.
Yeah, well, it's a good investment for these times. I have like for those for everybody who can't see me, I have these giant headphones and then this microphone that's on a stand, which is the same thing I use if I have to do something in front of court. But I think one of the first times I had to argue a Zoom hearing, opposing counsel called Jeff from our firm afterwards and was basically like, yeah, Yvonne did a good job. And he was like, man, that was a real intense setup though. So I think on the Zoom, everybody was kind of making fun of me behind my back.
I did not realize you wore the headphones in front of a judge. That's that's bold.
Well, it sounds so much better than just using like the built-in mic in your laptop, but our microphone doesn't have built-in headphones anyway. I got to figure that out.
Yeah.
Well, so I'll go ahead and tell our listeners a little bit about the terrific result that you all got recently. And as you mentioned, Jay, this was what I would consider still a COVID trial, and certainly the way you all had to work it up was during COVID. And so the amount of time with which you were able to get this case to trial and try the case is really impressive. So I want to make sure we dig into that. But first, I'll tell our listeners about the case. So the case is Alton G. Godwin and others against Eaton Asphalt Paving Company. We'll probably call them Eaton. This resulted in a $74 million verdict, and I will explain a little bit about how we got there, and then we'll dig into it. So on the morning of January 9th, 2019, Amy Skiba, who was a retired school counselor, was driving her 12-year-old twins to school on a two-lane road called Richwood Road. And she was going one way on the road. And in the meantime, in the opposite direction, there was a 2013 Chevrolet flatbed truck driven by a man named Devin Carroll. And he was driving towards her. And what happened is that the front tire of his truck went off the side of the road, and eventually his rear tires, it was a dually type. I don't know if dually is a Southern term, but
what it is.
Dually.
Yeah. Okay. The rear tires followed, and Mr. Carroll lost control of the vehicle, and he hit a driveway that was off on the right, and that sort of further lost control. And as he came back on the roadway, he essentially didn't have control of the vehicle. So he went towards oncoming traffic and hit Amy's Honda Accord, and she died on impact. So tragically, both of her twin kids were in the car with her when this happened. And then even worse, her third son, who was 17 years old at the time, was driving himself to school along the road behind her. And so he actually comes up on the accident scene before first responders do. And so all three kids witness this tragedy and the death of their mom. So just really unimaginable. So how does this happen? Why isn't it just a simple road wreck case? Well, one of the things, the main issue here is that Eaton, the asphalt paving company, had incorrectly re-paved the road about 2 months before this accident. And it's a sort of scenario I think a lot of people can picture without really knowing how much is involved in this sort of repaving situation. And that's one of the things that we're going to talk about. But Eaton had basically gone in, they were working under a state contract to, it sounded like, grind down some of the pavement, repave the road. And what they were supposed to do was put in these safety wedges, so that, because what happened is once they repaved the road, the pavement in the repaved section is about 1.25 inches higher than the old pavement. And so there's a couple things that you can do that you guys know better than me, so we'll talk about it to deal with that. But this company didn't really do anything. So what that meant was that you had this higher section of pavement that there was really no warning that you were about to go off of, and was very difficult to get back onto once you had basically gone off of that ledge. So it turns out that that's what had happened with Mr. Carroll's vehicle. So once Jay and Ron dug into this, they found out that the paving company had not done what it was supposed to do under the contract, had not done a good job. But rather than accept responsibility for anything, Eaton, the asphalt company, really blamed it on the state, said, hey, the state said state didn't do anything about it. The state said that we didn't have to mill the road, basically to grind the asphalt down, and blamed it on the driver of the Chevy truck, Mr. Carroll. So lots of issues in the case going forward, including some toxicology results that we'll talk about for Mr. Carroll. But the case was tried just recently on July 12th, 2021 in Boone County, Kentucky, and the jury found in favor of the plaintiff, as I mentioned. This case was brought on behalf of Amy's 3 surviving children, and the jury awarded $24 million in damages to them, which then where that number came from was $3 million for the emotional distress. I mean, all 3 kids had witnessed what happened to their mother, and then another $5 million for loss of parental consortium each for the 3 kids, which is where you get the $24 million. And then the jury also elected to award $50 million in punitive damages, which it's certainly a battle, as we know, as we talk about the show a lot, to even get punitive damages. And to get an award of this side is really tremendous and just shows what the level of work that Jay and Ron put into this. There's so much I want to ask you guys. There's so much good stuff to talk about here. But before I go too far into asking you all about the facts of the case, I do want to back up to what you mentioned earlier, Jay, which is that this accident happens shortly before, I guess, the pandemic really gets going, really right before. No, like a year before. But you're having to litigate everything, and you managed to get this case to trial when everything kind of around the country is really slowed down. So in addition to you guys correcting me about anything I got wrong about those facts, where we'll have time for that, where I'd really like to start is how you all kept this case moving when so many things were getting bogged down.
I'll let Ron. I'll let Ron address that, because I mean he was lead on this case, but I mean some stuff he did to keep their feet to the fire is really what got us to trial. So I'll kind of let Ron take the lead on this, because he really made the defense work.
So right, the incident happened in January of 2019. We were hired pretty much, I guess, February of 2019. We used an accident reconstructionist that, Jay does so much trucking accident litigation that he has a lot of accident reconstruction people that he knows, and one in particular, Joe Stidham, who he likes a lot. We had to go out to the scene. Jay and Joey went out there and did all that to figure out, we had a feeling this sounded like a road edge case, but we needed to make sure. So a long way of saying that this didn't get on file right away. So once it did get on file, then we had to amend to bring in the state, the Kentucky Transportation Cabinet, because they oversee everything and they authorize the work and they did the inspection. That added another little bit of delay. So by the time COVID hits in March of 2019, I think we had taken a couple depositions, but it was mainly like records, custodian depths. I think Jay did. So when we get to the substantive depositions in this case, and we took a lot, it was COVID, and Zoom depots. The very first Zoom depot we did, I was so ignorant of Zoom and using exhibits, I could not do the deposition without Jay to show the exhibits to the. I didn't even know how to share your screen. Now I'm like a ninja on Zoom.
Right.
But we really just put our foot on their neck, and we never let up. And the lawyer on their side, God bless him, we were just asking for depositions. Anything he balked at, we did not hesitate to go to court. We got to depose one person twice because of him improperly instructing the witness not to answer questions. So we were just very, very aggressive. And to be honest, one thing about COVID and the pandemic was that I had just come out of a very large mass tort, an MDL I had settled in Chicago. So my calendar was kind of clear. And then with COVID, that made it even more so. So for me, this case was completely the focus of my practice for all of 2020. And I think the opposing counsel got the feeling that I worked on nothing other than the case, because we were just in his ear constantly. But yeah, we took all these depositions by Zoom, and it really worked out great because, we could be at our desks. Jay would be at his office across the hall. I'm here. We had so many exhibits. We had all the contracts and documents between them and the transportation cabinet. And, Jay would help me with the exhibits. I'd have them all on my desk. So I have hard copies. We had exhibits up for the witness. And we were just able to really, I couldn't believe the quality of what we got from the depositions. Being old school, I'm used to being there in person and just getting after somebody to get what I want. And I wondered if we would lose that effect going through a camera, but I don't know, I'll let Jay answer. I don't think we did. I thought we really got amazing testimony and depositions given that they were by Zoom.
And I agree with it. I felt that we got, and I was starting to do remote depots before COVID hit because I just got tired of travel. Obviously that got enhanced once COVID hit, but outside of a few witnesses, I just can't see myself wanting to travel for in-person depots because I feel that when I take a depot by Zoom, that I'm not in the room and the conference table right in front of the witness with that kind of animosity and that conflict. There's that separation by screens, and they feel a little bit more relaxed, but they're staring right at you. You're staring right at them. And then we put the document up and you can have them side by side. It's pretty powerful, especially on playback. And I felt that because of potential delays, because of make sure you hear, I found that the witness is more attentive to the question and then easier to just give you an answer and agree with you. And so the approach that we took was that Ron took the lead in the majority of the depositions. Like the first deposition taking the case, when I do cases, I like to do a records custodian, kind of a version of a 30B6, but just of a records custodian. And I don't like to take a substantive depo till I get the documents. So I get a human under oath and I go through all the documents that they produced. It's a boring depo, but it's important because it helps us get additional documents, go to court with compel motions that we have an actual transcript on. So we did that first, and they produced a ton of stuff. We then filed up supplements. We got those documents. Now Ron was ready to take the first substantive deposition, which happened to be the vice president of the company, and it went great. He got to depose him again. But we decided, because of the newness of COVID and the way Ron does a lot of his, even in trial, he's not really an outline type that he'll have for ideas, but he's just feed off the witness, feed off the document. So instead of him having to worry about sharing screen and zooming in here and circling this, I was like, we're in separate offices. There's no feedback. I go, I'll be on Zoom, video on, I'll be muted. I'll just be your document guy. So I would pull a document and I would have everything I already had exhibit stickers on. And then I have it set up on my PDF, that Adobe, that if I need to add an exhibit sticker with a new document, I can add it on the fly electronically. And then I just email to the court reporter. So Ron would be talking about, Jay, pull up exhibit 5, the contract. I'd pull it up. He'd be talking about, without him asking me, he said, well, look at the second paragraph. Jay, zoom in there. And I'd zoom in. And then I would just take the highlight feature and I would just start highlighting or circling what he's asking the witness about, because I know it's demonstrative at that point. And if we ever played it back to a jury, they would see the live annotation with the witness's face. But we spent a lot of time on the documents, what was important about them. And I think that me displaying them, it took some stress away from Ron, or responsibility, and he could just focus on getting what he needs for the case. And if you ever saw the depositions, I mean, they were about as flawless as you can get. And I think the tag team approach was really helpful on that.
Yeah, one more thing, and then we'll move on off this topic. But I just thought it was funny that the system worked exactly like Jay described it, and it worked so well that in the first couple of depositions, the defense lawyer was asking Jay to pull up exhibits for him.
Yeah.
Right.
That's always nice.
That's awesome.
And that's when Jay's just a little bit slower than he normally does. No, I have to say, because we've done a ton of Zoom depots since this has all started. And, and I've heard a lot of lawyers say how they don't really like them. I'm the opposite. I actually do like them because just for what you two said is how you can use the documents, how you can put them up there. And then probably my favorite thing, and I'm saying this as I'm sitting in a hotel room getting ready to do depositions of a defendant doctor in his office tomorrow, so I'm breaking that rule, but is that you can spread out all the documents in your own office and just have them where you want them, and it's just so much quicker and easier to move through things than when you're sitting in the same conference room with the defendant. So I actually agree. I mean, I think that the video depositions and Zoom depositions can go very nicely. The only thing I would say is that you do have to get yourself prepared ahead of time.
Yeah.
Yeah.
And I think the only depositions that Ron took in person were the investigating officer right before trial and the paving company's doctor in West Virginia. I think every other depot he took that I took was Zoom. And so from January, if you take out the records deposition, it was like June of 19 before the transportation cabinet got brought into the case. So take that one out. From February of 2020 until June of 2021, we took 30 depositions.
Yeah. Wow. And then how did you, so this happened January 9 of 2019, and you're trying it by July of 2021, which even without a pandemic is pretty fast. So how were you able to get on the trial calendar so quickly? Because, here in Georgia, not only do we have cases that are older than ours that the courts will want to move along before ours unless we get a special setting, but we have the criminal dockets that are that they're putting ahead of the civil dockets. So that's kind of pushing everything back. So how were you able to get this case to trial? I mean, I guess by July 2021, and I guess what kind of things did you have to do with regard to COVID at trial?
So we asked for a trial date very early, and we were, I do a lot of cases in federal court, and sort of contrary to the normal plaintiff, I like federal court because I love having that schedule, right. And I like having deadlines and know when my trial date is. And in state court, it's so variable. And we have a lot of judges here in Kentucky who will not give you a trial date until the case is finished and you've already mediated even. But this judge doesn't do that. He kind of does the federal style where he'll give you a trial date and then he has an automatic pre-trial deadline order that backs up from that trial date. So, we know how the defense lawyers are, where whatever you ask for, they're going to say, "Oh, judge, my trial calendar is full." So I just went really early and asked for the trial date. And so I believe I asked for it in the summer of 2020. At that point I think we'd taken like the records custodian deposition was it. But my pitch to the judge was, I can try this case in 5 days. This is not a complex case. It turned out to be more complex than we thought, but it wasn't, it wasn't a pharma case or something. So, and so the defense lawyer, complained and whined, and the judge set it a year out. So I leave the courtroom kind of upset, but ultimately that was the perfect amount of time. So that put us on the clock, and we had 1 year now to get the case ready for trial. And then to answer your question about, older cases being on the docket, there was a more senior case that had the same trial date as ours. And I still to this day do not know why, because we were at court for the final pretrial conference, and that lawyer was there too. And he said, "Really sorry, but we're the older case than you, so you're not going to go to trial." We are. And then he got up and the judge said, "You're not going to trial. They are." And I will never know why.
I mean, ours was a 2019 filed case, and theirs was like 2017. I mean, yeah. It was a decent amount older. To answer the criminal docket stuff, yes, that is a concern, especially in some courts. But what our two judges in Boone County, our circuit judges, what they do and what our particular judge has in place is, and he will edit as needed, but his standard order is there's 1 week that he has set aside for criminal trials,
Right.
another week for civil trials, and then the alternating weeks is his regular motion docket. Like on Tuesdays is his docket, and he hears it. I mean, it's on the civil docket, and foreclosure and all that type of stuff. So he tries to keep. Now, if you have a big capital murder case or something, right, or you have a complex case, and if you set it, that's what happened in our case. It is, he set for 5 days. All the defense objected to was for the trial date, and the judge overruled it. And as Ron said, pick the trial. As we got closer to trial, they moved 2 or 3 times to continue it, and kept saying this is a 2-3 week trial. And at the final pretrial, maybe jumping ahead, but the final pretrial, the judge goes, he goes, guys, when this was said, I wrote down 5 days. Someone told me 5 days. It was Ron, and so no. And the defense says, well, we objected to the trial. It goes, yeah, and I overruled it, but you didn't object to 5 days. You get 5 days to try this case. Mm-hmm. And Ron stood up pre-trial a month before trial and goes, no problem, judge, we can do it. And defense like, we can't try this in 5 days. Yeah. And judge looked at Ron and said, you all can get your proof on half the time. Ron said, yep. And we left the courthouse going, okay, now we gotta.
Yeah, we were lying at that point.
Right.
Because at that point, the KYTC was still a party in the case. The claims for the estate were still in the case with another lawyer. And we also had Darren Carroll, the driver, we had to name as a defendant, and he was still actively in the case with his own lawyer. So we're looking at like 5 lawyers for every direct and cross. So 5 days was never going to happen. Yeah. But fortunately,
for the record, we weren't lying to the court, but
you were ambitious.
We were being very optimistic. How about that?
Right. Yeah. We just, as most good plaintiffs lawyers are, we're always ambitious and optimistic in how we can try our cases. Right. I do want to get into.
I do one thing. Get to it. I want to talk about later, because what Ron just said. I want one of the best things we did besides what we did during COVID, as we get closer and you all talk about trial strategy, how we strategize to put this case on in really 2 days of proof. I mean, that was also, we think, the beauty of why we got the result we did, because of how we tried it. Obviously, we'll get to that, I'm sure, at some point in your questions, but I don't want that to be lost.
Well, it is. I mean, I want, there's actually a lot there that I do want to talk about, and I want to talk about some of the procedural aspects. But one of the things that I was thinking as I was reading Ron's opening, and Ron, you mentioned it, which was, all right, we've sort of held this off, but Mr. Carroll had methamphetamine in his system. He's driving a flatbed truck. I mean, so you have this flatbed truck, goes off the road, comes back onto the road. Maybe he overcorrects, maybe he loses control, whatever, but then he causes it. On the one hand, especially when that case first comes into the office, I'm wondering if you're looking at this as, well, this is more of like a trucking type claim. He loses control, he's the one at fault. And then not only did you not really pursue, you didn't pursue that claim at the end of the day. You basically defended him at the end of the day, and really polarized the jury into this. It's either Eaton or it's Mr. Carroll. And you showed why it wasn't Mr. Carroll. But that's a pretty gutsy call, to say, we're going to go after one or the other, and we think you need to put everything on Eaton, which is what you ended up doing. And then I guess I want to kind of tie into this, and this is opening up a lot, is I was wondering what happened with the I'll keep wanting to say the DOT, but the Kentucky Transportation Cabinet, I think is what you call it, the KYTC. What happened with the claims against them?
So the KYTC claims were dismissed on summary judgment. In Kentucky, they have immunity for all acts that are discretionary, and that you can maintain a cause of action against them for acts that are ministerial, but then done negligently. And so we knew that the KYTC KYTC for us was a bigger fear than the guy on meth driving the truck, which people have a hard time believing. But people like to, it's like I do pharma cases and people want to blame the FDA. Why did the FDA approve the drug if it's so dangerous? Why did the KYTC approve this road if it was not done right? So, we worked to really get the KYTC out. We supported their motion for summary judgment, even though we had named them. And that's because in Kentucky, if there's an adjudication on the merits, then there is not supposed to be apportionment. And there was not an apportionment instruction in this case to the KYTC, which again scared us more than the driver on meth. But, I don't want to say it's routine to get the KYTC out on immunity in these cases, but it's close to it. I mean, I think most of the judges around the state know that they generally get out on immunity. And Eaton had never filed a cross claim against the KYTC. So they didn't have an expert to be critical of the KYTC. And we took the one that we had and basically jettisoned his opinions that were negative to the KYTC. So when it came time for summary judgment, there simply wasn't any evidence in the record that anything that they had done that was ministerial was done negligently.
Okay.
And so they got out on SJ, and then by that, there was no apportionment to them, which, we're going to talk a lot in this about how our success in this trial was not really what we did in those 5 days, but what we did in the 2 years leading up to them. I mean, we were really playing chess in this with all of our strategizing and how we got the case to where it was. But the decision that we made on how to deal with the KYTC was one of the best ones we made, and we executed it flawlessly. I mean, not through any skill of ours really, but just things fell into place.
Well, and the concern was, trial was July 6th, and on June 29th, I believe, is when the judge issued the order granting the KYTC summary judgment. So, I mean, less than a week before trial. The concern we had two concerns. One was what Ron just laid out. If they're in trial, if they're in the apportionment scheme, that was concern one. But concern two was, under Kentucky law, if the judge had denied the summary judgment motion on qualified immunity, the state has an automatic immediate right of appeal, and they were going to appeal, and we would have lost our trial date.
And we would have lost it for a year minimum.
Right. And so that was our other fear of we had based on the chess we played and the strategy and everyone preps for trial at some point. We really prep for trial a year out. We did our heavy prep 3-4 months out, but every move we made was decisive and was intentional, but we had no control over the summary judgment. And if it was denied, all that work we did, all that strategizing would have just gone out the window, and we'd still be in the Court of Appeals.
Wow. Yeah. So, and then with regard to the other driver, because one of the things that we didn't mention is that Mr. Carroll, I think, was actually facing some criminal charges
and not indictment for wanton murder.
Right. Wow. Okay. And so not only, by the time you got this case to trial, were you essentially, not putting any blame on him and showing why this wasn't his fault, but you guys even took the step, if I understand correctly, of going to the DA, showing your evidence and showing why there shouldn't be criminal charges against Mr. Carroll. Is that right?
Yeah. So, that's a needle you have to thread very carefully. And, early on in my career, I was a criminal defense lawyer, and, I had cases where, my client had allegedly caused harm to somebody, and there was a plaintiff's lawyer involved, and maybe they needed my guy to plead to something that wasn't intentional, so there wasn't a exclusion in their policy of homeowners or something, so they could get recovery. And I had been down that path several times, and I really had seen, and my wife is a prosecutor, so I know what makes the prosecutor mad and what they find, to be acceptable in terms of us intervening into their world. And so what Jay and I did was we didn't ask for any favors. We didn't tell anybody what to do. we just said, hey, I know that you've got this case and you're operating under one set of assumptions. But it's based on only what your investigating officer did at the accident reconstruction, the day after the accident. Here are some depositions you may want to read, because it's a lot of stuff that you don't know about. And the criminal defense lawyer for this guy does know about him. And so, if you have any questions or if this changes your mind about anything, let me know. And they read those depositions and got back with us, and they were like, wow, it looks like the road edge had a lot more to do with this than the fact that he was, on meth. And their own toxicologist had said the meth level was in kind of the inconclusive range, which, they have beyond the reasonable doubt burden of proof. So at that point, they were like, the prosecutor was a very smart guy who understands prosecutorial discretion. And basically at that point, he's like, look, if the family thinks that this is the asphalt company's fault and that's where their justice lies, then, we don't want to pursue a criminal prosecution that we're going to lose on. So, they ultimately, with the family's blessing, dismissed the criminal case against Darren Carroll, which again, another one of these things that, we talked about and planned and strategized over and achieved before trial, that had he been still under criminal indictment up there taking the fifth, there's no way there wouldn't have been massive apportionment of fault to him.
Right.
So and one more thing we got right somehow.
Yeah. And a couple things on that. First, Darren Carroll, it was an older truck. It was like a 2003 Chevy. He had no insurance. So, he was going to help his buddy that owned the company do some side concrete work. So there was no insurance on the truck. And we'll get to that in a second on the investigation. But, we knew that if we could have just contacted the criminal defense lawyer and said, hey, here's all this stuff, but he didn't have to turn it over to the prosecutor. He can keep that for cross. We knew if we got to the prosecutor, it'd be exculpatory. He'd have to send it to the defense. And we thought that was the above board way to do it anyway. We don't want the prosecutor to think we're somehow trying to, bomb his case to help us. We just said, hey, this is out there. You may not be aware of it. Just read it. And we didn't do summaries. We didn't put our spin. We just said, here's some depositions. We think you should read these. And that's really all we did. And then had some calls, and then they talked to the family, the prosecutor, without us. And, and the prosecutor got to the conclusion that Ron said, and it wasn't just dismissed, but the judge dismissed it with prejudice. So all criminal charges out, which included speeding, which included distracted driving, texting, and we can get to the motions in limine on that stuff. But I mean, all those things were knocked down that were initial conclusions from the first reconstruction report. And it was helpful that the police officer in this case wasn't just an investigating officer, but he's an accident reconstructionist for Boone County. He does a really good job, to the point of our reconstructionist agreed with pretty much everything their reconstructionist did when he, remapped and diagrammed the scene and did the total station and did the markings. He got pretty much all of it right. So, I mean, the guy knew what he was doing. And something you had mentioned earlier, how did we look at this? Because Ron, I've had this discussion a lot. How many lawyers would have gotten this police report that saw speeding, texting, crystal meth,
right.
woman died, and then said, well, if the guy doesn't have insurance, let's just collect the uninsured motorist money. I mean, that 95% or more, I think, would have gone that route, because the police report didn't say anything about the road. So the question is, how did we get into that? So Ron got the case in the office. Ron got the case signed up. And to me is like, hey, can you get Joey Stidham and go to the scene? So Joey and I met him at the scene. And something that I'll show you this, because I know that there's a recorded podcast, but I want you all to see. This is what I saw mid-February of 2019. So 6 weeks after the crash is when this happened. So we're at the scene, and you just see this aerial photo taken by my reconstructionist drone, and it doesn't look like much, right? And down here where I do the X, the guy went off the road somewhere around there, okay? And he goes off, and he's going this direction. So the crash is outside the view of this picture. The importance of this picture is when you look in the top, those aren't clearing. Hold on a second. Let me fix this. When you look up here in the top, do you see that truck in the ditch?
Yes. Oh, yeah.
And do you see the police SUV in the driveway?
Yeah.
Okay. Do you see in the far left, do you see the flatbed tow truck?
Yeah.
Okay. Right before that tow truck was there, that's where we were parked. And this porta potty truck had just gone off the road, dropped off the edge, and took out the culvert. His wheels were completely turned under. And we pull up at the scene, the police are there, and Joey and I just walk over, and Joey gets his card out, hands one to the cop, and says, I'm investigating, the fatality that happened a couple weeks ago. And he goes up to the driver of the porta potty and said, what happened? He said, I'm driving down the road, and my tire drops off. And I couldn't get back on, and boom, big crash. He had to be towed out. So 6 weeks after our crash, just by happenstance, the one day we pick, there was another similar incident on the opposite side of the road. And when the jury saw this photo at trial, you can imagine. I mean, one juror actually said out loud, "Oh my God!" Like she covered her mouth and said, "Oh my God." But I mean that. So, just by I'm a big proponent. And most of my cases are truck crashes.
Right.
I'm a big proponent of the moment I get in the case, go to the scene. I go to the vehicle inspections myself. I give a talk here in a month in Austin, Texas about that. But I have a truck crash kit, and I go and I get under the trucks. I get dirty. I look, because you can't replace that evidence once you see it. At that scene, when we were walking the side of the road, my 10-year-old daughter would have been able to say, this is bad, because all the asphalt where our crash happened was crumbled and was high, and you could tell it was all fresh. And it just didn't look right. So the scene inspection, when I came back, I might even called Ron from the car. I can't remember. That's when we knew, okay, it's this road has a major role. We didn't know at that point what we would uncover in deposition, but
Right.
that scene inspection started the process of seeing how bad this was.
Yeah.
Go ahead, Yvonne.
Well, no, I was just going to say, for people who can't see it, I mean, it looks like a lot of the sort of busier 2-lane country roads that you might have in your town, in terms of, you've got the lines on it and it's paved, but there's almost no shoulder to speak of. So what's happening with the asphalt is really important. You've basically got it where it kind of drops off, and you've sort of got those, ditches on either side of the road. So for people who can't see it, and we can post the picture, we can share the picture somehow on social media or something, so folks can see it. But just if you don't know what to picture, there's not like there's a big shoulder there for you to just pull off on or be stuck. You're basically dropping off after that, unless you try to get back on the road, which puts you in a different predicament. And what were you going to say, Steve? Sorry.
I was just going to say that, we hadn't really talked about why a steep road edge drop off is so dangerous. I mean, some people might just think, well, what's the big deal? A road's a little bit high, you get off into the grass, you stop or something like that. Can you all just talk about, I mean, there's federal standards on this, there's AASHTO standards on this, but can you just talk about why when a road is high and there's no shoulder and it just drops off, why that can be such a danger, and why it can cause something like what happened here?
Yeah, so I mean, it's we actually had a model. We had an animation made for this case, and we never even used it. And you don't want to know how much money we spent on that.
I've been there. I've spent money on demonstratives and then just never pulled them out.
Right, but we had a model made, and that worked out great. And I used it during opening, because exactly, I had to teach that I needed the jury to understand why something that may seem so innocuous is actually so deadly right out of the gate. So we used our model and just demonstrated how when you drop off and it's a vertical face, even if it's 2 inches, 3 inches, this was our model. And that was what it should have looked like, with the safety wedge tapering the edge down.
Right.
So what you see there is the gray styrofoam is the original road. The black was what they put on top. And what they were supposed to do was that wedge, and they didn't. But the side of the tire essentially locks over that vertical face, and the person usually panics because it's natural to do so. You've gone off the road, and they have to pull really hard to get it to remount that edge. Well, if they're going 40 or 50 miles an hour, when they do clear the edge, they're now putting as much pressure on the steering wheel as they can. So the tires immediately flip to the left and they're going 50 miles an hour. They go directly into oncoming traffic if they're really unlucky and they hit a car and kill somebody or themselves. And then if they're somewhat lucky, there's nobody there, but they do go across the road onto the other side and something bad can happen. So, we had an expert who was going to testify at trial, but for some reason the defense agreed to stipulate to his opinions and allowed the judge to read them in, that 2-inch drop was hazardous, and that anything 4 inches or more was ultra hazardous. Wow. So we had places. Jay, what was the highest point on our road edge? Definitely more than 4 inches.
This was the gold in closing, but this was eight inches, and that's where he tried to get. That's about where he tried to get back on, and the asphalt crumbled. So, Ron having this on a screen and Ron talking in closing and opening about this, but this was two of our best pictures. There's one other that shows the road before, but 8 inches, and that's about the area where he tried to get back on, but he couldn't because the vertical face was way too high.
That is amazing that any road engineer or road company could look at that and think that that's a safe design.
And I think Ron said in closing, you have the transcript, when he said, you heard, what the judge said, anything over 4 inches is ultra hazardous. I don't know what you call 8 inches. I forgot what you said, ultra or double ultra hazardous, but Ron's like, oh no, there's a word for that. I think he said something like that in closing. It was awesome.
Yeah, it's crazy looking. It's got that sort of like crumbled Oreo look on the edges. Like it looks totally unfinished, super sloppy. And you all were able to uncover, or at least paint the picture for the jury, that that's a lot of what was going on, that basically they got the contract for this job and had a certain amount of time to do the work in, had other jobs that they work on that were bigger, that make more money. At the same time, the asphalt company does, at the same time that they've got this contract. And so basically they've got the 6 months to start on the contract. They don't do anything for a while, and the work doesn't really start to get done until the weather becomes an issue, because you can't do this kind of work below 40 degrees. So then now they're running up towards the end of the contract, after which there's going to be financial penalties for that. They're basically, it looks like a very sort of rushed last minute job. But talk a little bit about what you guys learned in terms of how the time and money factored into, or at least the picture you were able to paint for the jury factored into the kind of job that was done here.
Well, yeah, I think from a career full of losing medical malpractice trials, I've become a firm believer that you have to prove motive, or the why. Why did this happen? Not how did it happen? And you can go to trial against a doctor who misread an X-ray, and you're going to lose that trial every time. But if you go to trial against a doctor who misread an X-ray and you prove that the hospital had cut the number of radiologists back in order to save money, and that they were having to read films, 12 hours a day, and they were exhausted, you win. And here, this could not be, and it wasn't. This was not a winner if it was just, something. It wasn't done ideally, because there's probably lots of roads that aren't done perfectly. At the end of the day, this is not artwork. This is just throwing asphalt on the ground. But we had to show the why, and the why made it all make sense. And once we could demonstrate the why did this happen? Not only did that help explain that the road was the reason why, it also made it much less likely for them to want to point the finger, or for the jury to want to blame the KYTC or the driver of the other vehicle, because now you had someone who did something wrong and the jury understood why they did it wrong, which was missing with everybody else. So like you said, we dug into the discovery and just immediately figured out what happened, which is this is a company that gets $7, $8, $9, $10 million projects from the state to build highway interchanges and all these things. And this was a $180,000 project. They should not have even bid on this. This was such a small thing, and they just shelved it. And they did all their $1 million stuff all summer long and did nothing. And so we had a great demonstrative of a calendar that had every month that they had the project, and we had a red X through every day that they didn't do anything. And so them
wait, hold on. This is so awesome. We have to be able to share this video so that you can see this calendar that's basically 6 months, and almost every day is covered with a red X. It's so exactly. Good.
It looks like they did 4 days of total work. Is that right?
Right. And three of them were, you see the deadline on November, but really they had to finish by the 9th when they finished, because the weather on the 10th, it was all below 40 degrees. And we had another demonstrative that showed, I mean, we used so many boards in this case. These were all boards. These weren't slides. And a lot of the time in the courtroom, what I was doing the most was picking up and putting down boards. But they really worked so well. And so this concept that they ignored the little project that they were going to make no money on in favor of the big projects that they were going to make money on. Now the jury understood why, and that helped everything make sense. And I've, after trying cases for 20 plus years, I've just now, understood that it's not enough to prove the elements in of the causes of action in your complaint. These are regular people who don't understand that. These jurors, they need to understand the whole picture, and it needs to make sense to them. And so that's what I think we were able to do with that part of the proof.
And, it's something that, we decided we didn't want the entire trial presentation to be on a screen through a projector. We wanted, obviously Ron had the idea for the model, want something physical. We actually had a whole model, a replica made of the tire of Darren Carroll's truck with an axle. We never used it. It sat in the courtroom in the corner. We just didn't, because of, we'll get into it. Ron can tell you what a pivot we made in trial, why we didn't need to use it. But we decided we wanted boards, physical boards. And he had an experience when he tried a couple of the bellwether cases in MDL in Chicago on testosterone of some of these boards and timelines. So all the boards we had made, they were all dry erase. They were all magnetized. And then the timeline board was 10 feet, 2 boards hinged. But all these boards we made, we didn't end up not using them all, but we used most of the boards, but we also made up, and this was a great concept that he and I came up with, where we took from the video depots, I screenshotted every main deponent's face for the paving company. And we then had the printer turn it into like a 3-inch by 3-inch or 4-inch by 4-inch magnetized or magnet. So Ron could put the person's face up, or and we had boards where he could check mark or put their initials. And so he's actively doing that. And the jurors were just, when he's up there, got the witnesses off the stand going through 6 boards of facts, and they're saying yes, yes. And the jurors are just, so focused on that. We thought the boards, because the boards told our whole trial pretty much.
Yeah.
We cross-examined witnesses with boards that were already finished. Obviously we took them from depots, so we could back them up with impeachment. We never had to impeach a single witness with a depot. I've never had that happen because we had the boards there, and they knew what they had said in their depot. And I'd have them come get off the stand, walk down to the easel where I had the board, and I'd say, this is a rule, this is a rule, this is a rule, isn't it true? This is a rule. Yes, 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 yes. And you broke this rule, and you broke this rule. They had nowhere to run. And the jury's not just hearing that and trying to remember things they're hearing, because we're all better visually. They're seeing the witness agree to it in writing on something that I'm not writing on a pad up there. This is clearly the jurors understand. We came to court with, that must be real, and it's already printed. And that witness, that the vice president of the company came down and agreed with everything on that board. And then, like Jay said, I mean, some days at the end of the day when we were getting ready for this case, he'd come in my office and we would just sit around and literally think of what's the wackiest thing we can do next. That's when I was like, yeah, because in one trial I put their initials next to everything they did. And then we're like, no, let's put their face on there. Yeah. so we had face magnets made,
But the boards, I mean, the boards had to be at the printer by, it was 2 or 3 weeks before trial.
Right.
So that's what I was going to ask you. That's, I feel like a lot of the problem you run into when you want boards is when you come up with them and whatever the time constraints are.
We started our board prep in, I want to say April, might've been early May. And we met with our person mainly by Zoom. We did one in person, realized we can do it all by Zoom. And I mean, to the point of there's an app I like to use, but it's only on iPad. It's called WordFlex, but it's a living, breathing thesaurus. It's iPad only. And we had that out trying to find the right word. Like on that calendar you saw, it had that Eaton. Initially, we kept saying, I said disregard, and Ron said, no, we need a better word. Like disregard, it's close, but it's too we need something better. So I put disregard in WordFlex, and next thing that pops up was ignore. And he immediately was like, that's the word. Yeah. So we would he would do a draft of a board of the wording, and then I would look at it and then tweak it, shorten it. He and I would meet and then spend more time on just 1 or 2 boards, wordsmithing, getting it as concise as possible, as simple juror language, non-lawyer language, and then what emblem, what picture, what color, and then our illustrator then was able to take it, run with it, and we had a consistent theme of colors and red, bad, that type of stuff. But I couldn't tell how many sessions, how many hours we had just on the boards, but it was the whole focal point of our trial. And even if we didn't know what we wanted to do with a witness, I could just pull a board up and let's go through these.
Yeah, it's huge. I mean, it's huge because you've got having the physical boards is very different than screens and screen fatigue. So, people are visual learners, but especially now, probably with COVID, people just kind of zone out with screens. So how smart to have that much concrete stuff. Steve, I know I did it to you again. What were you going to say?
No, I was just going to ask, I mean, doing demonstratives is one of my favorite part of trial, just, trying to be creative and how you're going to make your point. But I have actually, I was actually just wondering, for those boards to make them both dry erase and magnetize, how much cost does that add per board from a trial standpoint?
It's sickening how cheap it was.
I mean,
really?
we kind of went to the usual suspects early on about getting boards made. And just so everybody knows, you're getting ripped off by those people because now we know how much it really costs to make a board. So I have a client from a car wreck case who is a graphic designer, and she can use the Adobe Illustrator program, which is essentially what you need to do to make boards. I learned that from being out with Rodney Jew once on a case. And so we called her and said, she has a full-time graphic design job for a big corporation. And I said, would you be interested in making some extra money working after work a few days a week and maybe a couple Saturdays? And she said, sure. And we told her what it would be, and she was excited. And I think she had fun. She charged us a very fair rate. I mean, that's, commensurate with what her professional time is worth. And she's, skilled and probably in her early 50s. And then she found the printer that she uses for her big corporation when they have big projects done. And then she told us how much it was going to cost. Jay, I don't remember. It was.
Yeah, I got it right. I have the invoice right here.
It was so much cheaper than people who do this for us.
The invoice from the printer, which was, let's see, how many boards were they? 1, 2, 3, 4. The invoice from the printer turned out to be around $1,200, give or take.
How many? Wow. For how many boards?
19, 20.
At least 20 boards.
And then
I have paid $300 for a board before.
Exactly.
Mm-hmm.
Oh yeah.
And then for our illustrator and her charge I got the invoice here. It was actually, I mean, it was pretty low. Oh wait, I was in the wrong section. Trial boards. Here we go. So her invoice was $1,338.
So
we got her and the boards for, let's call it $3,000, give or take. We had one board.
Basically, your total cost is about $100 a board, which is absurdly low.
Yeah,
that's fantastic.
Yeah. We spent more than $3,000 on the animation.
Yeah.
Wow. Oh yeah. Yeah.
Let's not get into that.
Yeah, exactly.
but no, and so it just, I think what some takeaways from people is find someone local who works for, find out, who works for, find them on LinkedIn or something, or who works for a hospital or a big company or a nonprofit that does their graphic design. And, you spend some time with them. It's not like the boards I showed you are like some trade secret. I mean, it's a calendar with red X's.
Right.
But the people that do these things are in touch with the local printers, and she shopped the printers and got quotes from all three and says, I like this one the best. And they can fit your timeline. And, so that's what I got to do is find someone local who does graphic design, someone in graphic design school at college or marketing school or something. I mean, just that knows how to do I'm tech savvy. I can't do those Illustrator programs. That's beyond my capability.
Well, Yvonne, I'll just let you know that, my oldest daughter is in college right now for graphic design. So we're going to put her to work as soon as she gets done.
There you go.
Plant that seed, Steve.
That's right.
So we talked a lot about COVID, but so it sounds like you tried this in July. It sounds like, you have all these boards. So did you have an in-person jury? Was everybody in the courtroom? Did you have plexiglass up or masks or what was the deal?
We got another time that we just rather be lucky than good. We hit that window before Delta came back and everybody thought COVID was gone.
That's right.
And it was no masks, no questionnaires, nobody got tested, no vaccine. We were all vaccinated. I don't know if our jury was, frankly, given sort of the political view of people in Boone County, I would imagine several were not.
Right.
But we did it. They were in the normal jury box, no social distancing. They were sitting next to each other. I was right up in witnesses' faces, and we just got so lucky.
Yeah.
Literally a couple weeks later, the brakes got slammed on and everything was closed down again. Somebody was looking out for us. I don't know.
Yeah.
Yeah.
And there were a couple jurors that started with masks during voir dire. One got on the jury, wore a mask a little bit, and then eventually took it off. But Ron and I debated this, and I made since I did jury selection, I just kind of made a gut decision, and I chose not to voir dire on COVID. I initially had some stuff built in. Ron's tied in with some just fantastic trial lawyers that do stuff nationally that had good success when they did cover COVID, but for some reason my gut says I don't want to get into it. Right or wrong, I just chose not to question, and the judge didn't have any COVID questions for the jurors. He did a little voir dire at the beginning, but very basic. But I chose not to get in that because I didn't want to get off track there, because I knew I had to talk about meth. So
right,
that was one bad thing to talk about.
Well, I definitely want to turn and talk damages for a second, but there's a couple more liability issues I want to hit. One is in almost every road design case that I've ever had is a go-to defense for the contractor to point the finger at the DOT, or in this case, the transportation cabinet, by saying, well, they come out and inspect it every day and then they signed off on it. So, that's it. And you did hit that, Ron, in your opening and closing. And I thought the way you hit it was really good. But do you want to talk a little bit about how you face that defense? Because that is always a defense for contractors in road design cases.
Right. So, one of the things we talked about in this case was that they failed to put in the safety wedge. And the defense was, well, they came out and inspected it and they could clearly see that there wasn't a safety wedge there, and they okayed it. So, we had to deal with that. And so what again, this goes to, you have to tell why, what was the motivation. And so Jay and I made a pivot in trial the case wasn't about that they didn't put in the safety wedge. I mean, there was maybe a legitimate defense that you could not put a safety wedge in on this road, given the site conditions. But what we made the case, you know what? Maybe you couldn't put a safety wedge here. Maybe absolutely they had a very good reason not to do it. That's not what they did wrong, folks. What they did wrong was they didn't tell the KYTC. So one of the rules we had is if you're not going to do something that's in the contract, that's fine, as long as you tell the KYTC, because the KYTC has to know everything. They're the ones at 35,000 feet looking at everything. And if you're going to pick or choose one part to take out, they have to know, because that may make everything else crumble. So the example that we gave was the milling, the grinding down the pavement so that it doesn't get higher. That was supposed to be done in the contract, but they didn't want to do it. But they asked the KYTC and they got permission not to do it. So I use that as an example of they knew what the rules were. They knew they were supposed to tell the KYTC and get permission if they didn't do something. So why didn't they do that with the safety wedge? And so what we said was they didn't want the KYTC to know they weren't putting the safety wedge in, because if they did, if the KYTC found out, then they would have made them go back and mill the whole thing. Then they don't finish on time. Then they lose money. Then they get fined. You know, it went all back to the why. And so it all fit together. They already knew that why. So when I told them that, now it becomes a situation where it looks like they concealed this
right
from the transportation cabinet. So when I say, yeah, the transportation cabinet said okay on the inspection, because of course that was an exhibit they used. And I said, it's because they didn't know. And the KYTC, it's an honor system. They rely on the contractor to be honest and to tell them, look, we don't think a safety wedge will work on this project. And I really went at that again and again with the jury, say, and maybe it wouldn't have, and that's fine, but they had to tell them. And because they concealed it from them, the inspection says it's okay.
And
so
Ron, you came up, what'd you call the KYTC during trial? They weren't the road police.
Yeah, they weren't. The KYTC is not the road police, which is something that I get from my pharma cases when I say the FDA is not the drug police.
Yeah.
You know, the FDA is not a bunch of people in SWAT gear descending into pharmaceutical companies to find out if their drug actually kills people. You know, it's an honor system, and you're supposed to do clinical studies. And if you see something that looks bad, you're supposed to tell the FDA.
Right.
And the same thing here. If you think you're going to have to make the road differently than the contract requires, you have to tell the KYTC. And you know, from our focus group work, we knew that the bigger danger to us than a driver with meth in his system was what you just said. That the jury will say, "What about the KYTC? They inspected it." You know, we did 3 focus juries. They all hammered the KYTC. So that was how we got around that, to make it that they concealed it. It was part of their scheme.
Right.
And all 3 focus group jurors, and the way we did it was, and Ron had done this on his testosterone stuff and learned, you know, we did a layered focus group where we had individual verdict forms or questionnaires for everyone had to do individually without discussing it. And each section or segment was new facts. And Ron just started out with crash, meth, speeding, texting, who's at fault, 100% Darren Carroll. Then he started to layer a little bit more and a little bit more. And once he got to they cut corners, then they started to share the fault. Then once he said, oh, by the way, criminal charges were dismissed, all 3, and then individually, especially collaboratively in the 3 deliberative groups, they all put 0 on Darren Carroll. They start out with 100. They all put 0 at the end.
Wow.
Wow.
Go ahead, Steve.
Well, the other thing that I did say we were going to talk about, and I just want to have you guys touch on real quick that we haven't, is so you were representing the 3 children of Amy Skiba. And I assume that she had divorced her husband, who was the father of the 3 children, Mr. Godwin. So there was actually a separate lawsuit brought on behalf of the estate of Amy Skiba and then by her husband as well. So I guess just talk about that sort of procedural part of it real quick about how that was handled. You all handled one part of the case, and then I guess there was another law firm that was handling the estate claim for Ms. Skiba.
Correct. And So the judge consolidated they were filed separately, of course, and then I believe on motion of the defendant, the judge consolidated them, and we had to do the case together. They settled literally, I guess, on the Sunday before trial started on Tuesday. And it was fine. You know, it's a lawyer who is a defense lawyer down in Lexington and takes plaintiff's cases every once in a while. And he was great to work with. And, you know, all the depositions, you know, we took the lead and we had our theory and our exhibits, kind of how we already said. And, you know, he was fine with that. And on experts, you know, he brought a couple experts to the table and we used some of it. And, you know, we had obviously our accident reconstruction and our toxicologist, but it worked out fine. And then with him settling, you know, again, going back to how we can get this done in 5 days, he settled. You know, he settled. The KYTC's out. These just kept removing lawyers from our trial and allowing us to be quicker. So it all worked out, you know, to have that happen that way.
Did the defense try to bifurcate punitive damages, or is that a Kentucky thing where you just do it all at once, or they wanted to do it all at once?
They didn't want to. They were Ohio lawyers, but I think they've done enough in Kentucky to know that that's a non-starter with Kentucky. There's actually losses that all must be tried together.
Oh, okay.
Wow. That's great.
Yeah.
I mean, you know, there's good and bad for doing that, but I mean, generally you know, with punitives in the first part of the case in Georgia, it's bifurcated. You know, there's a lot of evidence you can get in that you, if you try it all together, then you can't, that you wouldn't be able to get in if it was bifurcated.
Right.
Well, let's talk about the damages. So essentially the claims that you brought here on behalf of the kids were emotional distress for essentially witnessing their mother get killed. And from what you described in your opening, it sounded like there was some photographs and the way she was killed was particularly gruesome. You know, and then there you have a loss of consortium claim for the loss of a parent. So to talk a little bit about, you know, the damages in this case, and then how you presented those to the jury and got them to the point that you did.
Right. So the negligent infliction of emotional distress is a cause of action in Kentucky that is rarely used. And I'll let Jay talk about that next. And then, you know, the loss of consortium, we all understand that. We didn't use any of the groups. They made a motion in limine to keep out the photographs, and we did not use any of those. We didn't put the children on the stand. We didn't have the children in the courtroom. Jay told them during voir dire that we would not be bringing them in because we weren't going to make them relive this event. We did have them in at closing, but you know, we wanted to take the high road with the jury whenever possible. And I mean, we really wanted to have that their trust and that they weren't being gamed or taken advantage of or exploited, and that we weren't going to exploit these children. And I think that gave us a lot of credibility, especially when asking for large amounts of money. You know, I told them in closing that there was stuff I could have shown them and I did not. And I told them that we weren't there for their sympathy. You know, I'm a believer in using the term justice. I think that that has a lot of weight to it for regular folks on a jury, and that's what they want to do. I think most jurors want to feel like they did what was justice when they go to a courtroom and they see a guy in a black robe or a woman in a black robe, and lawyers, you know, that's what they think should happen. They have an idealized version. They don't know all the stuff we do about how the sausage is made. But so we gave that to them and allowed them to be that. And yeah, so I think that the amounts, you know, we weren't real wedded to amounts, and we didn't, you know, in Kentucky, generally on the jury verdict form, you know, you have the not to exceed and you have the numbers there, and plaintiffs' lawyers love that because they think it might be an anchor to get a bigger number. We didn't put those on ours. I wasn't exactly sure what I was even going to ask for going in, you know, like the night before closing. I kind of batted it around with Jay about, well, maybe I'll just give them some ranges, and that's what I did. And they came in within my ranges. You know, I think that it was, somebody told me once a long time ago that a juror would, and I don't know if this would work with children, but I think it did, that a juror is more willing to give money to someone for what they've been through when they hear somebody else talk about what it did to them rather than hearing them talk about it themselves.
Yeah.
And I think having this dad on the stand who's a big, tough looking guy, talking in a whisper and getting choked up about what his kids have gone through, and having the psychologist on the stand describe, the things that they had told her in session, clearly, worked.
Yeah.
Jay, why don't you mention what you know about the negligent infliction?
Yeah. And, and it kind of comes to that because, same thing. I mean, I do, a lot of brain injury cases, and I'm an officer in the AHA TBI group. And the way we prove the cases is we want someone other than the client talking about the deficits. And here, and Ron, you mentioned, Yvonne, early on in the intro about Ron's $7+ million verdict on the product defect case. It was a cochlear implant verdict for a kid. And part of the reason he got the verdict is how the defense tried to exploit the kid at trial. So, Ron had experience with that and said, we're not going to put him on. We're not going to go there. We can get this through other people. And we had reached out and Ron interviewed 2 of the eyewitnesses who called 911. One of them, she happened to be what's called a SANE nurse, a sexual assault nurse examiner. So she testifies in court all the time. And she happened to be on her way to work and got there and saw the kids, the twins that were 12 at the time. They were in the car, and she got to them pretty quickly and got them away because she knew that their mother was possibly deceased at that point. Got them away from the car, put them in her car. They had glass on them. She even testified, like, I remember when I get home and I had glass in my car for a couple of days that were just in their hair. And so Ron put her on as our second to last witness, and then he put on the psychologist. But there's another witness who called 911, and he gave some testimony about that. And it was actually the 12-year-old son after the crash got into his mom's purse, got her cell phone, called their brother who was 17 at the time, and he got to the scene before the police. So the one brother called the older brother, and he gets there. And so Kentucky back in about 2011, I believe it was, adopted negligent and basically did away with the impact rule. We used to have physical contact or impact. Otherwise you couldn't make a claim. And they adopted this rule called Campton out Tennessee that basically says, is that as long as there's expert testimony of severe emotional distress, then that's enough to make a claim for negligent infliction emotional distress. So, and it kind of did away with the whole zone of danger rule anyway. Mm-hmm. Just, hey, if there's severe emotional distress, well, the jury instruction talks about significant treatment or significantly affects their everyday life, and that was the instruction the court gave. And the kids only went to counseling a few times, a handful each. This wasn't a case where they needed counseling. It was apparent when Ron and I worked this case up that if there's ever a case for negligent infliction, it's this one. It's you don't need treatment for jurors to understand it. So that's how it was presented. We said, we're not putting them on the stand. They went through something that's losing your parents bad enough, but now witnessing it, being there, even worse. And Ron got the dad to talk about how it's impacted their lives. The twins were 15 or about turned 15 when trial happened. The oldest son had just turned 20, or was about to turn 20. And because he was almost 18 when the crash happened, that was one of the arguments that I'll let Ron address. He was 6 months from turning 18, which was something the defense focused on, which was a mistake. But they actually, after Ron, the dad gave just this, just gut-wrenching, genuine testimony about his kids. The defense lawyer is doing the cross-examination, covering they went back to school, their grades didn't drop, and said, they're still doing stuff with their friends, and they're still going to dances and after school activities. And the dad says, yes. And he paused, he goes, but without their mother. And I heard a juror go, oh, but the defense was like, well, they've moved on with their lives. This isn't a big deal. And the dad's, and that's what. So in closing, if you'd rather watch Ron's closing, I mean, that's something he focused on based on what they did in closing, trying to blame the kids for not testifying.
Oh my God. I mean, talk about a huge trial mistake, but yeah, Ron, you want to talk about how you handled that and what they were talking about, the almost 18-year-old son?
Well, I just pointed out sort of in a common sense way how ludicrous the idea was that somehow he suffers less than the other two because he was going to turn 18 in 6 months. And so they gave him the same amount, for each one, which in their motion for a new trial, they have raised as, an error that clearly they didn't do it right if they gave all the kids the same amount because they were different ages. But I just spoke to the jurors on that point in a way that was sort of along the lines of, are you kidding me? I mean, like, I have kids, you all have kids on this jury or have grandkids now or whatever, and this idea that this period of time means it's worth more. I just threw that out the window. And just talked about what it means to not have a parent, and for especially for in this way. But yeah, I like I said, I mean, we didn't want to put them on, and one of the things that I said is the defense counsel went on and on about how you can't use your sympathy, and I got pretty heated and just said, they don't want your sympathy. We're not here for sympathy. I said they got more sympathy than they know what to do with.
Right.
They got sympathy from their aunts and their uncles and their friends and their dad, and they've had sympathy for 2 years. And I said, we're not here for sympathy. We're here for justice. Yeah. That's what you get in a courtroom, not sympathy.
Yeah.
And the jurors were nodding and with me. So, that resonated. And then it made the defense lawyer's argument look stupid. So,
yeah. And for the listeners, the importance of the 18 in Kentucky, adult children don't have a claim for loss consortium. It ends at age 18. So they were trying to argue that since the twins are 12, they get 6 years consortium. But since the oldest son was 17 and a half, he only gets 6 months. So his consortium isn't as bad as his younger siblings, which of course we about fell over when he said that. But
yeah,
I mean,
yeah.
Well, and I don't know if you had a chance to talk with the jurors afterwards, but did you have a sense of what drove the punitive damages verdict? So the compensatory verdict was a total of 24 million. The punitive damages was 50 million. So obviously the jury, and after what you just said, I can see why the jury might be heated. But you want to talk a little bit about what, in your mind, drove the punitive damages?
So we know what drove it, and I'll let Ron. I mean, it's. We didn't talk to jurors. We were still in shock. It's Boone County. Right. I tried the case there 2 years earlier and lost. I just got reversed on appeal. But we were still just, the kids were there crying and the dad. But how we got the punitives, what motivated the jury? I mean, I'll let Ron. It started in opening. It started in testimony. And it's something that we didn't expect and we didn't hear till trial. And I'll let Ron tell you about it because it anchored his entire closing on punitives.
So going back, so as you can imagine, looking at those boards, our whole theory on punitives and the way we got past summary judgment on punitives and was based upon that this was reckless and wanton because they ignored this project knowingly and intentionally for months in favor of more profitable projects. So they were putting profit over safety. And then getting to your point, Steve, about the KYTC and trying to make this look like they had put their stamp of approval on it. The defense lawyer decides at the final pretrial conference to tell the judge that we've got this all wrong, and that something they had never said in depositions, no expert they had ever said, but he comes out of the woodwork with every contract requires a safety wedge. There's a page 14 in every one of these contracts, and they never do them, and the state knows it, and everybody knows it, and it's just something that's in the contracts, but these safety wedges don't work, and no one puts them in. And we're like, what? That? So when I'm putting on I have the KYTC chief engineer, and I said, tell me about the secret deal. And he's like, what secret deal? I go, the one where it's always in the contract, but you never make them do it. He goes, I'm not aware of that. And I said, if there's testimony today that they never do it and that's okay with you, is that truthful testimony? No. And then Jay had their expert accident reconstructionist on there who works for the KYTC all the time and said, is there a secret deal? And he said, no, there's no secret deal. Yeah, if it's in the contract, you have to do it. So we cut the legs out from under that. But then they put the vice president of the company on, and trying to get the secret deal testimony going further, says, how many times has page 14 been in a contract and you didn't do it and the state didn't say anything to you about it? And he goes, 80 to 100. So in closing, I go, folks, this didn't just happen on this road. You heard the testimony from the vice president. They have done this 80 to 100 times. That means there are 80 to 100 other roads in Northern Kentucky that are just as dangerous as this road. And I don't know if half the time they got permission and maybe half the time they didn't, or what the split is. I go, but you determine what percentage of the time you think they did it just like this and they concealed it from the KYTC and they didn't get permission, and you give them $1 million for every one of those. So I guess they took half. They took half of our.
I was just going to say, I'm surprised. I mean, part of me thinks that, they might have given 80 to 100 million, but I mean, yeah, 50 million. That's that.
Wow.
Wow. Well, guys, we've been talking for a long time, and this has been a really great discussion. I want to make sure, is there anything else that you want to make sure that our listeners know about the case, the Godwin versus Eaton Asphalt Paving Company case, that we haven't had a chance to tell them?
I think one thing that we did was, especially after that pretrial, we'd already had our boards prepared, but we got back and we I had a whiteboard up of things to do, and Ron and I would check things off the list, but Ron had drafted an order of proof, I think right before the pretrial, I believe, and kept tweaking it. And he kept saying, how can we get this on in 2 days or 2.5 days? Really 2, because jury selection took all day Monday. So how can we really get this on? And he was very, very careful on the order of proof and about how long he thought. And he's like, I think I can get most of our case in through 2 people, and that we don't need these other people that we had subpoenaed or we're going to call. So in most of our exams, I mean, it's not like we did 2-3 hour direct exams. I mean, they were an hour, some 45 minutes, but we got everything. There weren't wasted questions or fluff, it was right to the point. And just like scalpel, surgeon with a scalpel, we got to the point, and that was the importance of how efficiently we planned it, and we put some people out of order. We called the cops second, we called Darren Carroll third, and we were going to call them later, but we put them on early. And Ron's like, hey, day one, they've heard opening, they heard about the meth, let's get the officer on, let's get Darren Carroll on, let's all confront this day one, and then the rest of the trial focus on Eaton Asphalt. And that's what kind of what we planned. So the prep in advance, not waiting 2 weeks or a month before trial, these many, many months of strategizing and having a plan, and having plan A, plan B, plan C if we need it, I think is a big takeaway for everyone to really put thought into it, because I think the efficiency helped us.
Yeah.
Yeah, and I'll just say that I think that really making the case about the road and not about the meth was what we focused on. And no matter what was being said at trial, no matter how, even if they were scoring points, the defense lawyers were scoring points and getting some good testimony, which they got at trial, it happened. But if it was about the road edge, we just sat back and smiled, because they were talking about the road edge and they weren't talking about a guy on methamphetamine. Mm-hmm. And, Rodney Jew talks about staying out of the purple box, and the purple box in this case was methamphetamine. And so we just did everything we could to stay out of it. And they went along with us. So if we talked about the road edge, they had to get up and talk about the road edge. And every time they did that, they weren't talking about meth. And it was just keeping it short. I mean, I will never I will try to never again do a 3-week trial. I mean, you know what you're going to get from these witnesses. Just get it. Just get it and sit down. The jurors' attention span in this case, we had a new witness popping up constantly, and they never had time to get tired or to fall asleep after lunch. It was quick. It was moving fast. We were animated. We're moving boards around and models. There was a lot of energy all the time, and nobody droned on. And I think this jury, I had never seen a jury so just laser focused on a case like this one was. And I think doing it quickly was a big part of that, and using physical things instead of screens was a big part too. So yeah, a lot of things came together that were luck, as I've already mentioned, but we also took advantage of those opportunities, and it all came together, and it was an outstanding result for a great family.
Well, and trial lawyering is taking advantage of opportunity. I mean, so when you see those things, even arguments by the other side, and then turning them to help your case like you did. And then, as my very wise wife always says, is luck favors the prepared. So yeah, sometimes, people who prepare a lot tend to be more lucky. But anyways, this has been just such a great show. I think just filled with great tips on strategy and how you try a case efficiently, quickly, and just get a tremendous result. One last thing, and then I'll let you two go. We've held you for so long. I think you said the status of the case is a motion for new trial right now.
That's correct. We'll have our response filed this week. It's not a compelling motion for a new trial.
Right, exactly.
I just have to say that the last motion for new trial that I had to argue against, some of it was based on the damages award, and the defense lawyer kept saying that it was inconceivable that the jury would award this amount.
Did you put up Princess Bride?
Can you believe I didn't? I wanted to so bad, and I just didn't know if the judge would get it. He kept saying it's inconceivable. It's inconceivable. And I wanted to be like, I don't think that word means anything.
And something that the listeners may not know that's unique to Kentucky. Other states don't have this, but in order for them to appeal, they have to post a supersedious bond for the full $74 million, and post-judgment interest is 6% compounded annually. So interest has started, and so that's a big number.
And I guess we should ask: is no caps on punitive damages, or are there?
No caps in Kentucky at all.
That is fantastic. How did you all manage that? Just out of curiosity.
We have a good Trial Lawyers Association with a good executive director who's a very shrewd lobbyist, and we don't pick sides. We give to pro-justice candidates, no matter what party they belong to.
Yeah.
And we just tell people to protect the Constitution and the 7th Amendment, and that has gotten traction up there. And not to say we haven't had some tort reform here and there, but compared to our neighbors all around us in Tennessee and Indiana and Ohio especially, we're way better, way more justice in Kentucky for people.
Well, that is fantastic. I mean, I big shout out to the Georgia trial lawyers. They do the same thing. I can't say that we've been as successful as it sounds like you guys have been in Kentucky with avoiding caps, but we'll just great, fantastic work. For a very deserving family. Let me just remind everybody, we've been talking about the Godwin versus Eaton Asphalt Paving Company case, which resulted in a total verdict of $74 million in July 2021, so just a month ago. And we have been talking to Ron Johnson and Jay Vaughan of Hendy, Johnson, Vaughan, Emery. And if you want to look up Ron or Jay, go to justicestartshere.com. Guys, thank you so much for your time.
Great. Thank you all so much for having us.
Yeah, thanks for having us. It was enjoyable to relive it.
Yeah, absolutely.